Did we give you the remote, or did we end up with it?
I'm Eleanor, by the way. I'm nice to meet you. Maybe.
No, I haven't. I'm sure. I thought I shuffled it towards. It's where it's
Jackie's got it. Yeah.
Oh, good evening, and thank you for joining us today in this discussion and presentation on Don't Lose Out on Costs, an update on offers, misconduct and personal cost orders. Our first talker I'm pleased to invite is Brenda Tronson from Level 22 Chambers. Brenda was called to the bar in 2008. Her background spans commercial and public law. Her principal areas of practice are administrative law, civil and human rights, including commercial law, constitutional law and disciplinary matters, discrimination, evidence and procedure, migration law and privacy and government information law. She appears for a range of clients in a variety of state and federal courts and tribunals, and frequently is briefed to advise and appear in relation to important or complex statutory interpretation questions. Before she came to the bar, or was called to the bar, she was an Associate to Justice Crennan of the High Court of Australia and completed a Bachelor of Civil Law with distinction and a Master's of Philosophy at the Law at Oxford University. And prior to that, she worked for a while as a graduate at Freehills. She is extremely qualified to talk on costs. I noticed she acted in some acts for the Council of the Law Society in the matter of Burjo and Council of Law Society, which dealt with a number of ethical and conduct issues. So I'll hand it over to Brenda in respect of her talk this afternoon on Office of Compromise.
Thanks very much, Paul, and thank you to our audience, both in person and online. I'm going to be talking today about where offers go wrong. So, in other words, where offers don't provide the cost protection that they're often made in order to provide. I'll be focusing on 4 situations where that might happen. The first is where an offer is made purportedly under the rules, but it doesn't comply with the rules. The second situation I'll talk about is where an offer is not a genuine offer of compromise. The third is where an offer is not left open for a reasonable period of time. And the fourth situation I'll talk about is where the nature of the particular proceedings is such that the ordinary or usually automatic cost consequences might not follow. I'll focus on the UCPR where the rules are relevant. There are similar situations where other rules of court apply in other jurisdictions, although there's sometimes more leeway. So, for example, under the federal court rules, it's easier to make a cost-inclusive offer and still comply with the rules. As a brief primer, in Part 20, Rule 26 of the UCPR, we've got the rule that we're all very familiar with now, which provides that an offer may be made and also sets out the requirements for making that offer such that you can get the automatic cost consequences, which are then set out in Part 42, Division 3 of the UCPR. And those cost consequences are provided for in Rules 13A through to 15A in particular. But broadly speaking, if you do better than your offer, you've got an option to apply for indemnity costs for at least part of the time of the proceedings. So, with that in mind, turning to my first category, which is where the offer's made purportedly under the rules but doesn't comply. You've got my handout there, and for those of you online, it should have been emailed to you as well. The first case on the list is Whitney and Dream Developments, and that's a case with which probably everyone's familiar. It's where the Court of Appeal said conclusively for the first time that if your offer does not comply with the rules, you do not get the automatic cost consequences. You might be able to say it's a call-to-bank letter if you've complied with the principles in call-to-bank, but you don't get the automatic Part 42 consequences. Now, of course, Whitney considered the old form of the rule, which said an offer had to be exclusive of costs, And the court said in Whitney that that meant you couldn't even say that the offer was, or that part of the offer was that costs be paid as agreed or assessed. Now, turning then to the second case on the list, Curtis and Hardman Shire Council, that's the case where the Court of Appeal considered for the first time the new form of the rule, which is what we now have. And the relevant part of that rule is now that the offer must not include an amount for costs and must not be expressed to be inclusive of costs. Of course, other amendments were made as well, including that it's expressly easier for defendants to make a cost-inclusive offer in some circumstances. In Curtis, the court held that that form of the rule, that is, must not include an amount for costs, must not be expressed to be inclusive of costs, allows an offeror to say that costs are to be paid as agreed or assessed. And so when that language is used, the offer complies with Subrule 2, paragraph C. So that's the main difference between Whitney and Curtis, and it arises from that change to the rule. Turning then to my second category, which concerns where an offer is made but is held not to be a genuine compromise. This bites particularly with Calderbank letters, but it can also apply to offers made under the rules. And that was the case with the third case on my list, Abdi and Abdi, which is a recent consideration by Her Honour Justice Ward of whether an offer included a genuine element of compromise. Her Honour acknowledged that a walkaway offer can be a genuine compromise, but whether it is in a particular case can be difficult to know, particularly at the time that the offer is made. It's especially true when an offer is made early in proceedings, where the amount of costs forgone might be quite small, and so the level of compromise might also be small. One of the big takeaways from that case is that where a walkaway offer is relied upon, when you then come to make your application for indemnity costs, it's absolutely essential to include evidence of the amount of costs that would have been forgone had the walkaway offer been accepted at the time. It's probably even more important with offers under the rule than with Calderbank letters, because for a Calderbank letter, of course, the question of reasonableness arises as at the date of the offer, and the amount of costs your client has forgone is something that the other side might not know. Miwa and Siantan, which is case number 4 on the list, is a case that did involve a Calderbank letter, and there the court held, as you'll see in my summary, that it's not unreasonable to not accept an offer, bearing in mind that that's the Calderbank test, where that offer requires a complete capitulation. And that was the situation the Court of Appeal held applied in Miwa. That is, that the offer did require a complete capitulation on the part of the offeree, and so it wasn't unreasonable for the offeree not to accept that offer at the time it was made. The next two cases on the list, Evans of Rob Evans and Regency Media, both really just provide the Court of Appeal's version of what Her Honour Justice Ward said in Abdi and Abdi 10 or so years earlier. That is, even where you're looking at an offer of compromise under the rules, it's not enough for it to just be an offer. It must be an offer of compromise. That is, it must include some level of genuine compromise in the offer itself. And then finally in this category, Hegde, which is a federal court case, involved a situation where there was quite a complex exchange of offers, ultimately resulting in settlement, but not settlement of costs. So the court still had to determine the question of costs. In that case, the court held that the back and forth and the fact that some of the offers probably didn't really involve a genuine compromise meant that ultimately the appropriate position was that each party bear its own costs. It really reminds us that we have to be quite careful where there is that exchange of offer and counter-offer, as we so often see, which does make cost applications, if there's no settlement, much more complex. So just bear in mind that as you're making those offers of compromise and the counter-offers and responding to them, how that all plays out might mean that you don't get that fairly automatic consequence from the offers that you might ordinarily expect. Turning to my third category, which is where an offer is not left open for a reasonable amount of time, you'll see number 8 on my list, Cooey Communications, is a Court of Appeal case which considered whether an offer that was made quite shortly before the hearing, within a couple of days before the hearing, had been left open for a reasonable period of time. The court considered factors which included that counsel would be focusing on preparation for the case, and so although everyone's minds were turned to what was going on and they could be taken to understand the issues and so forth, making an offer so late could be a distraction, and that affected the assessment of whether the time that the offer was left open was a reasonable one. It reminds us that it's really quite critical when we get to the pointy end of litigation. We're in that last week of preparation and we think, oh, really, we should settle this if we can. We have to turn our minds to what is reasonable in the situation, not only to try and get the matter to settle, but in order to provide that cost protection if the offer that we make doesn't result in settlement. Cases 9 and 10 are simply recent considerations of that point in Cooey, so I thought they would be useful references for you to have, but I don't need to say anything about them further. The final point, or my final category, is where the nature of the litigation, the nature of the proceedings is such that the ordinary cost consequences that are set out in Part 42 might not apply. And this can apply particularly where the proceedings or the area of litigation is one where the usual order is not necessarily costs follow the event. My case number 11, Grogan and Blacktown City Council, is exactly such a case. It's in an area called Class 3 proceedings in the Land and Environment Court, and because I suspect most of you don't know what that means, I'll just tell you it's where land has been compulsorily acquired. There's been an offer of compensation made in accordance with the compulsory acquisition legislation. The landowners objected to the amount of compensation, and that goes to the Land and Environment Court. The case is about the amount of money that is payable. It's not about whether or not the land should have been acquired. And in general, in those proceedings, if the landowner does better than the offer of compensation, then the acquiring authority will pay their cost of proceedings. And that's true even though sometimes what happens is the offer of compensation has been made here. By the time you get to hearing, the authority's position might be here, so above that original offer, and then the applicant, the landowner, is seeking something more than that. So even if the authority wins on their case at proceedings, if that case is above that original offer of compensation, they will be expected to pay the cost of proceedings. That was more or less the situation in Grogan. But also, the council had made an offer of compromise and beat its offer at hearing. The primary judge said, fine, you can get indemnity costs. The Court of Appeal said it's more complex than that, in part because this was an area where the landowner could ordinarily expect to get their costs of proceedings if they succeeded in the sense of beating that original offer of compensation. And in part because at the time the offer had been made, although it wasn't too far out from hearing, points of claim and points of defence hadn't been finalised, expert evidence, which is really critical in these cases, hadn't been finalised. And so the parties didn't necessarily know or what the issues would be as they crystallised at hearing. So that starts to look a lot like a call-to-bank analysis. That is, the court was thinking about the reasonableness of the refusal of the offer at the time, and found that it wasn't unreasonable for the landowner not to accept that offer. And this, combined with the uniqueness of that area of proceedings, led to the court otherwise ordering. So the automatic cost consequences in Part 42 didn't follow. That brings me to the end of my list of cases. It also brings me to the end of my time. Thank you very much, Paul.
Thank you, Brenda. Thank you very much. Are we having questions at the end?
Up to you.
Jim, I don't know if there's any questions from the floor on Office of Compromise, or you wanted to save them to the end. I was just going to ask one why I had thought about it, but with a walk away, it seems to me that you run the risk, if you make that offer, that it's not seen as a genuine compromise, that you really have to pay some money to make it a compromise.
Absolutely. For a defendant or equivalent, it's a very good idea to put some money on the table as well as make it a walk-away offer, unless you really beef it up in the offer with an explanation of how much you are foregoing by simply making it walk away.
Okay, if there's no further questions, or there might be questions later, I'll move on to our next speaker, which is Jackson Rogers, to my right. Jackson was called to the bar in 2021 after spending a long time as a solicitor in a general commercial practice, if I can call it that. He specialises in complex investigations and disputes resolutions. He's recognised for his technical acumen, his strategy thinking, and his ability to provide astute commercial advice. Prior to coming to the bar, he acted for large corporations, individuals, and advised them in the following areas of corporate and commercial, bankruptcy and insolvency, competition and consumer, property and strata and employment and workers' compensation, negligence and insurance, administrative law, including privacy and information, and wills and estates. Jackson has extensive experience litigating before courts in New South Wales and the Commonwealth on behalf of a broad array of clients. He's adept at alternative dispute resolution, including mediation, arbitration, and expert determination, and has negotiated favourable settlements for many clients. He has a passion for constitutional law and empowerment. His practice areas are in commercial law, bankruptcy, competition, consumer credit, consumer law, and he has been on both sides of the fence in applications for indemnity costs involving party misconduct. Knows how joyous and how miserable the situation can be.
And related to the last point that Brenda made, I might say that one avenue that a party that's in a strong position could think about, in addition to or in lieu of a walkaway offer, is to point out the reasons why the other party has no prospects of success, and that's what I'll be talking about. I'll be talking about party misconduct and indemnity costs. So obviously we start from Section 98 of the Civil Procedure Act, where the court is given an unfettered discretion, including the power to award costs on the indemnity basis, and that power must be exercised judicially. I'll refer to case names only briefly, because I think you should have them all on the list of authorities. So that's the case of Oshlack, with which we're probably all familiar. Now, as that case makes clear, a unifying principle for when indemnity costs shall be awarded in favour of a party has not proven easy to formulate. Outside of special cases, such as a trustee's right to indemnity from the trust assets or specific provision, for example, in relation to offers, the cases have generally focused on some misconduct in the course of the litigation. Such misconduct has included where a party has misled or sought to mislead the court, where a party has abandoned claims, where a party has caused unreasonable delay or expense, where a defendant has unreasonably delayed an admission of liability, the case of a vexatious litigant, and where a party or person has been held in contempt. Two further and perhaps more common examples are what I would like to focus on today, and those are where a party has maintained a claim or defence that they should have known had no prospects of success, and a related situation where a proceeding was maintained for an ulterior purpose. I'll look at these types of cases in the following way. First, by revisiting the general principles by reference to the landmark cases. Secondly, by looking at some more recent cases and examining any trends, if that's possible to discern, by looking at judgments. Thirdly, I'll discuss some practical ideas of what to consider when contemplating or when defending an application for indemnity costs on these grounds. And fourthly, I'll finish with some theoretical questions which will hopefully lead into what Katherine has to say next. So, no chance of success, the case law and the principles. The source of the no chance of success misconduct is often divined from the case of Fountain Selected Meats. It's actually useful, I think, to understand what happened in that case to appreciate the types of misconduct that the court will consider worthy of some sort of approbation, although I'll come back to that point in a second. Now, in the case of Fountain Selected Meats, the plaintiff had alleged that a director had aided and abetted certain impugned, misleading and deceptive conduct. The case against that director was commenced in 1983, and shortly thereafter the full court of the federal court determined that in order to establish a case of aiding and abetting against a director, a plaintiff was required to establish that the relevant director was knowingly involved in the alleged conduct and, in fact, knowingly involved in each element of the alleged conduct, importantly. And this decision was confirmed by the High Court in 1985 in a case called York and Lucas. It was found by the court in Fountain Selected Meat that the plaintiff had no evidence that the director was knowingly involved in that sense. And the court found that by the time the High Court handed down its decision in 1985, the plaintiff ought to have been aware of the implications for its case against the director and therefore awarded indemnity costs in favour of the director. And the quote, which I'll read out, is probably well known to you, where the court said, "I believe it is appropriate to consider awarding indemnity costs whenever it appears that an action has been commenced or continued in circumstances where the applicant, properly advised, should have known that he had no chance of success. In such cases, the action must be presumed to have commenced or continued for some ulterior motive, or because of some willful disregard of the known facts or the clearly established law. Such cases are fortunately rare, but when they occur, the court will need to consider how it should exercise its unfettered discretion." A useful consideration of the principles of Fountain Selected Meats is contained in the case NMFM Property and Citibank number 11. Got to number 11, that case, where Justice Lingren ruled that the party seeking an indemnity award is not required to prove actual knowledge that the party knew that its case had no chance of success, which would set the bar too high, but also has found that the misconduct is not established by submitting that the losing party ought to have been advised in terms of the judgment that was ultimately handed down. The court determined the question by considering whether the causes of action advanced by the losing plaintiff were arguable, and after finding they were arguable, dismissed the application for indemnity costs. Now, closely connected to the question of no chance of success misconduct is the question of the ulterior motive. You'll note that in the decision of Fountain Selected Meats, the court found that where there is a case that is being advanced with no prospects, there is presumption on the party that the position has been taken for some ulterior motive. There is no requirement on a party seeking an indemnity costs award on this basis to establish the ulterior motive. However, if that ulterior motive can be established, then that will greatly strengthen the application for indemnity costs. And the reference there, and I actually failed to put this on my list of authorities, so I'll read it out in full. The reference there is Cultus, CULTUS Petroleum, and OMV Australia, 1999, NSWSC 435. Some other principles that are relevant to no chance of success misconduct, and these are relevant in some respects to indemnity costs more generally, is that they are, of course, that such awards are, of course, not designed to punish the losing party, but rather to compensate victorious party, or the party that was found to be vindicated, and the reference there is Hamilton, New South Wales. That sits perhaps slightly uneasily with the principle of public deterrence, which the courts have found is a relevant factor to be considered when a party makes an application for indemnity costs on these grounds. And the reference there is Huntsman Chemical Co. and International Pools. That is President Kirby in dissent, but nevertheless later affirmed on that point. As I said, there is no need to prove the ulterior motive, and the reference for that is J Corp, Proprietary Limited, and Australian Builders Labourers Federated Union of Workers, WA branch, one of the longest party names you could possibly think up. And that is in the list of authorities, and that's a decision of Justice French, as he then was. A further principle that needs to be considered in these applications is that the courts have found that the classes of case are not closed in thinking of what constitutes misconduct. There's a recent discussion of that in the case of Kelly and Liu and others. Kelly was acting as a liquidator in this matter. The reference should be in the list of authorities, and it's not. Oh, yeah, it is. So it's a 2021 decision of Justice Markovich. And that's an interesting case. It's a recent case, and it's worth having a look at in terms of for anyone considering making an application for indemnity costs or defending one, because it is a complex decision where the court does look very carefully at what each of the parties did, and in light of the judgment that was ultimately delivered. And in the end, the court ruled that, and I'll just quote from the judgment, the court said, Justice Markovich said, "I found that the contentions put by the shareholders in their 3 July letter," and that's a defined term, "had no merit. Given the roles of Mr Warboys, one of the shareholders, and Mr Barnett, the director of the second shareholder, as directors of Halifax, for most of the period in which the company operated until it was placed into administration, it is difficult to conceive how they could press these contentions." And sorry, I should have gone back to lay the scene a bit more. The contentions being put by the shareholders were that the liquidator had engaged in more or less misleading or deceptive conduct. I'm satisfied that those contentions ought never to have been made by the shareholders, given their involvement in and necessarily understanding of the business of Halifax. Ultimately, the shareholders elected not to participate in the proceeding, thereby no longer propounding their contentions, but that was only after the liquidators had undertaken a significant amount of work in order to establish, ultimately for the purposes of the proceeding, why it was that the contentions were without merit. That gives you some idea about what the court might consider. There's also the case in the list, a recent case and a decision of Chief Justice Bell in Brown and Stables Perisher Management, which I'll also commend to you. I won't go through what happens in that case. So the test is, well, actually I'll return to that point later before just looking more at more recently at some trends, if, as I say, trends can be divined by looking at cases of judgments, a list of judgments. One of the trends that is evident, and probably in my time as a practitioner, and maybe Paul can speak to this, has become more evident, is that indemnity costs application and possibly awards are more common than they used to be. They're talked about in the 1980s cases as being awards that are must be exercised very sparely and so on. Now it's nearly, well, maybe not par for the course, but it's certainly in prospect in any case that an application for indemnity costs will be made. There's a judgment of Chaina and Alvaro Holmes from 2008, which talks about that. And the quote is from Justice Baston: "The tendency to grant indemnity cost orders is more ready than in the past. And he ties that to the passage of the Legal Profession Act 2004. So these cases are more common and should be considered, as I say, in every case. And I think it's a duty of the practitioner to consider whether an application actually can be made properly. Having said they're more common, that doesn't mean that they necessarily follow even in a strong case. And there's a recent case of Mergolo and AAI Limited number 2, which is on my list, which was a successful summary dismissal of a case. And the defendant duly followed that up with an application for indemnity costs and no doubt thought that it was on very strong grounds. The court looked quite carefully at Mr. Mergolo's position, and he actually raised a quite interesting and novel point of law relating to Section 50 of the Limitations Act in New South Wales and what the meaning of knowledge was, and in the context of discoverability of a cause of action. He confined his case solely to that ground. So the court thought that this was a novel point, there was no decided judgment, and he hadn't run 5 or 6 different points. He'd confined his case, and in that circumstance found that the defendant was not entitled to indemnity costs. Now to get to my philosophical discussion, I've got some references there in the case list to some of the more fanciful family provision cases, claims. My view of the law in that the law in that area is that indemnity costs are becoming more common, and that certainly payments out of the estate are less likely, or may be viewed less favourably than they were in the past. So that's something for practitioners to consider. The philosophical questions that I have, and I'll try and relate this back, is there was a line of authority that said to the effect that indemnity costs were not to be ordered on the basis of the conduct that led to the proceeding, as opposed to the conduct during the course of the proceeding. But I wonder whether, and maybe some people will have something to say about that, whether that, and that's a New South Wales decision, Court of Appeal decision from 2001 called Harrison and Shipp, obviously predates the Legal Profession Act 2004. And I wonder whether that, in light of this trend of cases, still holds, including where the courts will look at what did the party know about the merits of its own case. Now, a practical consideration. Sorry, I wanted to get back to my practical considerations before getting to my theoretical discussion. So if I could just jump back onto practical considerations. Obviously, as I say, I think a practitioner has an obligation to consider whether an indemnity costs application can be made. The question is, so consider the judgment, and obviously consider the judgment carefully. If there are, for example, indications that the judge considered that arguments were finely balanced, or that there was a particular finding against one party, that party's credibility that may not have been known, that may not have been anticipated that their evidence would unfold in that fashion, then perhaps there is no ground for making the application. If you can prove, even by inference, an ulterior motive, then I think you're on very strong grounds. Now, what about, and I should go back to first principles, that when you're considering making an application for indemnity costs, the first principle to consider is there some special or unusual feature that would entitle this award? So that's really what you're trying to, the box you're trying to tick, ultimately. In response to an application, as practitioners, first, I would say don't despair. I don't know if you've got something to say about that, Paul. it's becoming a more normal occurrence, as I say, in civil litigation, and perhaps it should be. Really, it's not about a punishment. This is about compensation, and perhaps parties should be properly compensated. Secondly, I'd say, and this applies as well to making the application, is I'd say consider the economics. How much time and money is going to go into the application, and what's the difference between the indemnity cost award and the usual award? Again, in response to the application, consider the judgment carefully. Be aware, and this is perhaps the most important point in response to the application, be aware of the presumption of the ulterior motive. So even if the applicant has not put forward in its application for indemnity costs that there was an ulterior motive, you may be, the evidentiary burden is on the responding party, losing party, to, if it can, lead some evidence to say why there was no ulterior motive or what it had been advised, what advice it had received. Because the question is, for the application, if a party properly advised. And so this question becomes, what advice did the party receive? Now, as legal practitioners, this can cause significant conniptions, because the question becomes, should the client be leading evidence about what advice it received from its lawyers? And so the theoretical question becomes, since the Legal Profession Act 2004 was passed, to what extent is a legal practitioner under an obligation to inform a client of rights to seek to adduce evidence about the advice that was given to the client during the course of the conduct of the proceeding? And the related question I'd put is there a basis for a no chance of success misconduct case against a party in a regime where, if that party has a legal practitioner, that legal practitioner has signed off as to the reasonable prospects of the position that the party is taking? And that perhaps leads into Katherine's discussion.
Thanks, Jackson. I was going to say, from a solicitor's point of view, the thought of the word indemnity cost when you're on the other side of it always sends a shiver up your spine, because you're worried about all your disclosure issues through the case, all those sorts of issues as you're doing it. But I do think too, and I think it's, when I think about it when you're talking, it does seem to me it's almost a default application now by counsel at the end. Because the worst case scenario probably, if they successfully, is the ordinary costs order, and they'll seek it on an indemnity cost basis. Being at Pattison Hardman, drawing bills, we do see a mixture of orders. We're parts of it, obviously, based on offers of compromise. We see the indemnity cost orders. We do see those cases where those conduct cases come in, where the chances of success, where they've been, when they've received those indemnity cost orders as well. Coming to your point too, that point you were saying about whether there's a real difference between an indemnity cost order in reality and an ordinary cost order, that's an interesting one, especially in the federal court, where it's, you're drawn to a scale where the scale will go out the door and you draw the bill at large on what your rates are, because you're often curtailed by the scale. But the scale of the federal court can be quite generous and you got that, sometimes you've got that uplift fee, which can be, get your fees quite up to almost an indemnity basis at the end. You are looking on an ordinary basis. I think you're looking at fees somewhere between 65 to 85% of your, depending how you manage it generally, on an ordinary basis, say a Supreme Court garden variety piece of litigation. But an indemnity basis, you would be looking at much, 85 up to, 95% of your costs. So, it certainly is.
And it's also the presumption, if it does go to assessment, that the onus is really on the party against.
That's right. The onus.
An indemnity costs order has been made to satisfy the assessor that it wasn't reasonable.
So you're in a much better position to say, look, you're going to uphold those costs as well. And then, of course, you talked about chance of success. We had a role, I don't know if it's still the same as Supreme Court. In some cases, we saw gross lump sum cost orders as well and looking at the conduct of the parties as well. So they would, I think this party would then have satellite litigation sort of things through the assessment process and delay it. So then you'd have the gross lump sum application as well.
Yeah.
Again, not supposed to be punitive, but to ensure that the party that was successful and had to jump through all the hoops doesn't then have to jump through further hoops through the ongoing assessment process.
And I think that's one of the really important things. In the UK for 20 years, there was a whole real problem with satellite litigation, particularly on costs, and we never seem to have that same issue in Australia. I see these changes as being moving towards that a little bit, but what the court's saying about lump sum cost orders is a little bit of a caution to parties to say there has to be an endpoint. This shouldn't go on for too long.
If I might just chip in there, in relation to the satellite litigation, sorry, I'm Paul's colleague at Pattison Hardman. And what we have seen, I think, Paul, you may agree or not, is that we've seen an exponential rise in the utility or the utilisation of the appeal process running from a cost assessment process. Generally what we have your assessment, you have a review from assessment, and then you have the ability to appeal up to the District and Supreme Court from that decision. When I first started because in Australia 20 years ago, appeals were unheard of, whereas now that we see the list is filling up and filling up with those, and so I think there is a view in relation to that, and from the Victorian paper that's come out recently, where they're talking about the deregulation of cost down in Victoria, but then the imposition of some of the cost budgeting scenarios that come from the UK. It's a concern for me, but there does seem to be an eye on this idea of a finality and a certain early finality in relation to these costs.
Yeah, so in sum, I think if an indemnity cost order is sought, a gross sum cost order should probably be sought at the same time. It's
an interesting one, because the other one we were discussing this, Charles, the other day was we saw a bit of a pushback from the Supreme Court recently where some cases weren't successful on gross lump sum cost orders. We're wondering whether, because the Supreme Court has this assessment system set up where they have their own manager saying, well, look, I don't really want to do this, I'm quite busy, you go off to the assessment system. So
fair enough.
Maybe there's a bit of a pushback. But this seems to, maybe it's the flavour of the month, there seemed to be a run on there for a bit, and then the Supreme Court, it is almost without failure in the federal court at the default position. You should almost always ask for a gross lump sum cost application, I think. A different system, the taxation process, just a bit long. Perhaps it moves into the next talk, because as you were talking, Jackson, I was thinking almost if you have this poor chance of success and ulterior motives, the below torch, the forensically must start looking at the conduct of the solicitors advising. So maybe it's looking at the next talk as well, which is Katherine Oldfield is going to present who sits to my left, who's on the next topic is about the conduct and personal cost orders, which is even scarier than indemnity cost orders. And I was just going to say before I introduce Katherine, I did see there was a decision, and I won't mention the senior counsels, but he had to put an affidavit, there was no cost order at the end, but he had to explain, this was some conduct issues, and had to explain himself to the judge in the Supreme Court and file an affidavit about his submissions where some threats were made. So a published decision, but so it can happen to the best. Yeah. But Katherine was called to the bar in 2010 after being admitted as a solicitor in 1996. She has a practice in the area of medical negligence, catastrophic injuries, coronial inquests, disciplinary proceedings, professional negligence and costs. She has appeared in the ACT Supreme Court, New South Wales Supreme Court, New South Wales Court of Appeal, ACT Civil and Administrative Tribunal and contested disciplinary actions. As a solicitor, she worked predominantly in personal injury and medical negligence with a full caseload and also did a stint of working for Ward and Keller in Darwin, which must have been quite hot. Katherine has been a member of the New South Wales Bar Association Costs and Fee Committee for 3 years and practices in law cover matters, specifically dealing with cost issues. Katherine has considerable experience in cost issues from a practical point of view as a solicitor in a busy practice, but also in the area of her practice where cost issues invariably become a major issue at the conclusion of a hearing or even in settlement discussions, and not to mention her practice focusing on costs. Her talk is on an important topic this evening, giving rise to personal cost orders. And we're just talking about perhaps the greater threats to these now that in the way in the litigation. So a very important topic, and also the reasonable prospects of success that solicitors sign off on the statement of claim for damages cases.
Thank you. So, conduct that can land you with the bill rather than the client. It is the scary end of the Civil Procedure Act, Section 99. Section 99 applies if a court considers that costs have been incurred in one of two circumstances. The first is by serious neglect, serious incompetence, or serious misconduct of a practitioner. And secondly, improperly or without reasonable cause, where the practitioner is responsible. So, as Jackson described in the cases he was talking about, it's a very fact-generated set of circumstances. It's a lot of fact-finding that has to be undertaken before decisions can be made about whether or not there is, in fact, exposure. So let me start with what serious means, given that it applies to 3 of the types of conduct described. Firstly, these 3 areas of conduct are one concept. They are not 3 separate categories of conduct. So you consider them as a single concept. And Her Honour, Justice Ward, as she then was, in NHB Enterprises and Corrie number 5, not number 11 as Jackson, but number 5, was a dispute about the use of confidential pharmaceutical formulae that involved password-protected cloud-based data. Now, it's about 150 pages in judgment, and I didn't really understand it. Certainly not what it was about. But what I can tell you is that she considered the allegations that were made about misconduct or conduct that was said to give rise to a Section 99 circumstance. The first was disclosure of the password. The password was in fact the subject of a solicitor's undertaking not to disclose. So disclosure of it was pretty bad. And Her Honour said it was incompetence in the sense of a lack of care, but it was not serious neglect or serious incompetence, mostly because emails can be sent in haste without sufficient attention, apparently being paid to the contents of the email chain. And this password was attached to some attachment 5 pages down on the email string. So, we all know emails can be inadvertently sent to the wrong person and attaching the wrong material. It is misconduct, it is incompetence, it is neglect, but it's not serious enough for a Section 99 order. So that's good news. When advised that there had been a breach and the solicitors concerned undertook what they said was an investigation, the investigation was inadequate and incompetent, but again Her Honour found it was not serious incompetence because even though they did investigate, the solicitors actually did not realise that they had in fact disclosed and they did not deliberately conceal that disclosure. So sometimes it pays to be too dumb to know that we're in breach. Okay. The next one was a failure to disclose that they knew that another party had set up a new email account was in and of itself not serious misconduct or serious incompetent because no one seemed to understand how the system could be accessed and how that capacity interacted with the search and seizure orders that prevented that party from gaining access. But when they failed to take action because they had become aware of what the first defendant was doing, that he was accessing the emails via another name, and they became aware that that was happening and allowed that to continue, it was serious incompetence in the sense of a serious failure to be cognizant of their professional and ethical obligations. Okay? They were aware that another party was secretly reviewing the plaintiff's access to data. They took the view that that might be turned to their advantage. I mean, that's a huge tipping point if ever I've seen one. There was an obvious risk that the party obtaining secret access might alter or delete particular documents that were the subject of the search and seizure process underway. And doing nothing in the face of that knowledge was not consistent with their ethical obligations, was akin to equitable fraud. So, but that failure in and of itself was not serious misconduct, because the solicitors had not turned their mind to that issue. So, that is what serious means. Turning to unexplained conduct. Okay. Rahman and Al-Marama number 2 was an appeal from an unsuccessful application for an extension of time under Section 109 of the MACA. So we all know these applications. It goes on appeal. Brereton, His Honour, Justice Brereton, with Marr and Leeming agreeing, found that the appellant, plaintiff, had provided a full and satisfactory explanation for her conduct and her instructions, but her solicitors had given absolutely no explanation for why they failed to act on those instructions for 3 months. And His Honour found that he was satisfied, absent any explanation from the solicitors whatsoever, that they have acted at least negligently, and that the negligence was more than mere, which suffices to engage the Section 99 jurisdiction. Absence of skill and experience. Canon Finance Australia and Reliance Medical Practice. It's a breach of contract claim for, God save us, hardware, software and cloud-based services in a medical practice. A doctor engaged in a contract that turned out to be far more expensive than he anticipated, so he decided he'd stop paying. When he was unsurprisingly sued, he concluded he'd been had, and he cross-claimed for misrepresentation, fraud, all those sorts of things. His Honour Justice Campbell found that this was obviously a difficult claim involving a degree of complexity. He said that the doctor essentially failed because he had failed to satisfy the court on the balance of probabilities that his version of events on contestable facts should be accepted. His Honour took into account, helpfully for the solicitors, that the solicitors were relatively junior and had briefed, experienced counsel. Counsel's written advice was not produced. Privilege had been expressly waived, but the applicant for the Section 99 order did not call for the advice. In terms of the requirements of Section 99, His Honour noted that it needs to be borne in mind that the expression serious incompetence or improper connote a high degree of departure from the standard of competence on the one hand, or ethical propriety in the conduct of the litigation on the other. So, the degree of delinquency required. RRZ and Fogo Brasilia Holdings was a little skirmish about proceedings commenced pending expiry of a limitation period. The solicitor expected representative proceedings would take over, but did not, when he served the proceedings, invite the defendant to consent to a stay until that position was clarified. In the circumstances, the defendant made an application for security of costs for $250,000. It's important to know that the solicitor was acting pro bono, that the corporation plaintiff was a shell company, that the sole director and shareholder was impecunious. So, the solicitor, in addressing the security for costs application, served affidavit material that was manifestly inadequate, which led to an adjournment of the security for costs application. And His Honour dealt with it thus. He did not categorise the solicitor's failure to advise that there should be an offer to stay proceedings as delinquent. He said, whilst the outcome has been unsatisfactory and some misjudgments may have been made, the court should be wary of treating too harshly solicitors who are prepared to act in the cause of impecunious plaintiffs who are seeking redress in respect of substantial losses. He said that where solicitors in those circumstances are prepared to act without fee, realism suggests that there may be occasions where misjudgments are made that do not warrant a finding by the court of delinquency of a magnitude sufficient to visit costs orders on the solicitor personally. So, proportionality. This is where Section 99 meets Section 56. We return to NHB Enterprises, the amazing email or password case, and to decision number 6 of Her Honour. The applicant made, in the primary matter, 7 distinct sets of allegations of serious misconduct, including perjury, within the course of the application, but only succeeded on one very minor point. The applicant argued that not awarding the costs of the application for a special cost order would be unfair if not awarded to them, given the issues of professional and ethical obligations as officers of the court. It would punish the applicant for bringing the application, and it would deter other litigants from making Section 99 applications. The respondent argued that significant animosity had driven the applicant to put aside commerciality and Section 56 obligations and effectively to leave no stone unturned to attack the solicitors in every conceivable way. And from Her Honour's judgment in number 5, that is not an unfair assessment. They also noted the unsuccessful allegations represented 85% of the issues before the court. And Her Honour found that on any view of the matter, costs of the application must be considered to be wholly disproportionate to the amount in issue, which was $100,000. It went for days and days and days and days. It must be recognised, she said, that there is a public interest in discouraging the pursuit of such applications in circumstances where the costs of taking that course are or are likely to be disproportionate to the amount sought to be recovered. And that actually echoes some of the comments we've already heard. So the last thing I will very quickly talk about is, well, what is a reasonable cause if you can get a Section 99 order for bringing proceedings without reasonable cause? His Honour Justice Bell, then the President of the Court of Appeal in Murinity and Mercia Finance Solutions, gave the judgment in an appeal from orders made by Davies in one of the Murinity and Newell sets of proceedings. The claim in this matter was for possession of land that had been met by allegations of fraud and conspiracy, which failed for lack of any evidentiary basis whatsoever. His Honour noted, the inquiry is directed to whether there was a reasonable basis for the allegations. An honest and genuine belief that a matter is reasonably arguable does not make it so. It is an objective question separate to the subjective belief or understanding of the solicitor. So, the take-home message is to reality check your allegations, your arguments, and your submissions. Lastly, a few things to know. Section 99 does not displace the law of contempt or abuse of process. It does not displace the court's jurisdiction in relation to governing the conduct of practitioners. It does not displace the uniform law or the solicitor's rules. As Campbell said in Canon Finance, there is no real difference in substance between the uniform law and the Civil Procedure Act rules in relation to this area. Both equate to, quote, not fairly arguable, unquote. Lastly, Section 99 is not the same as the test in the federal sphere. Arguably, it is substantially less onerous. If you want to avoid a Section 99 order, act in accordance with the Section 56 principles. Think about the proportionality of your conduct. That term, proportionality, is increasingly being referred to by judges. Record your work, evidence or material considered, reasoning process, consultation with others. And lastly, know your limits of time, your capacity and your knowledge, and manage the risks that poses accordingly.
Well, thank you, Catherine. I was just going to wonder, Catherine, this concept of equitable fraud, which didn't get there. No, it sounds serious.
It's very serious words. Everyone goes, oh.
But it wasn't enough to, no. It almost sounded criminal.
Well, no, fraud needs to be understood as a better type of fraud because equitable fraud can mean you just transgress some fiduciary obligation you may not have intended to do that.
Okay, so okay.
And it's that intent that she was talking about.
Right, yeah, okay. Well, they seemed to dodge a bullet there, didn't they? Look, I haven't got any questions myself, but does anybody have any points they wish to discuss? Okay. So, how does the questions work?
I'll read them.
Okay, thank you.
So the first question is, if a case lacks prospects, therefore a finding of misconduct, why isn't there a costs order against the plaintiff's lawyers rather than against the person relying on their professional expertise?
And that's the question I raised in my, because the no chance of success misconduct really predates this Legal Profession Act 2004 regime, which has now been updated and possibly strengthened actually in the uniform law. One thing to say to that is that it's up to the party that's making the application as to who it will seek indemnity costs from. Perhaps the trickier question that arises for practitioners is what obligations, as I say, are you under as a practitioner to advise the client in the face of an application for indemnity costs, particularly where one question may be that might assist that client is, well, what advice did I as the practitioner give that party? So it's a difficult regime. I think, Catherine, in your notes, you pointed out that there is some case law to the effect that, look, a personal costs order application against a solicitor is not to be seen as a substitute for a costs order against an impecunious party.
Yeah, so I think I can address that.
Yeah.
A Section 99 order, it is not a ground to seek a Section 99 costs order against a practitioner simply on the basis that you've lost against or you've won against a party and they are, for example, impecunious. Okay. Such applications are commonly brought in terms of an indemnity cost order is sought against the losing party, and in the alternative, a special cost order, a Section 99 order, is sought against that party's solicitor. They're two entirely different things, and whilst you can get a cost order against a party because they lost, and an indemnity cost order on a more detailed ground, to get a Section 99 order, you have to prove that the practitioner has done effectively something wrong that has led to the costs. And as Jackson said, the onus is quite high there. Whilst you can refer to the Uniform Law and Schedule 2, Clause 5 in terms of no reasonable prospects of success, but that's no reasonable prospects of success, not hindsight, no prospects of success because you happen to lose. If there was a reasonably arguable case, then you won't win a Section 99 application.
And there's a follow-up question, which is from the same viewer. Can a response to an application for indemnity costs require the applicant to demonstrate compliance with Section 56 of the Civil Procedure Act?
Well, Section 56 applies to both parties and practitioners. Did you want to deal with the parties section?
That applies more readily to indemnity costs applications on grounds other than no chance of success misconduct. So, for example, there being some improper conduct during the course of the proceeding that I talked about at the start of my presentation. Just to be clear, and because I talked about the presumption in the no chance of success misconduct cases, the onus is still on the applying party to establish that there was some breach of the Section 56 obligations. So that, and whilst evidence may be led that then shifts the onus onto the responding party, nevertheless the applicant bears the burden of proving that case. So I guess that's all I've got to say on.
I take the question as being, does the applicant need to show that they've complied with 56? And it seems to me that in part because they bear the onus, if they haven't complied with Section 56 themselves, they're going to run the risk that they don't win their cost application. So you might find as a prophylactic that if you can demonstrate you've complied with Section 56, it's a good idea to leave that evidence.
Yeah, and there's a good example of that recently. I just wonder whether I wrote the case down where a party was able to very comprehensively demonstrate that they had done everything they needed to do only in accordance with Section 56. They hadn't expended additional costs. Unfortunately, it came out of my final version, but it's a very recent decision of Hallen J, and it's in the family provision / probate space in the last 18 months.
There are no further questions online.
Katherine, I was just going to ask you, this whole concept you're on proportionality, there are a lot of cases that are run in superior jurisdictions that aren't always large money cases. They might be very important issues of land or intellectual property, which might be significant to someone's business. How do the courts reconcile, I mean, when I suspect the Section 99 application, but that issue where they have something very personal to that business which is worth protecting, whether as an example of land but in dollar values it might be quite insignificant.
My reading of the references to proportionality is not purely in relation to money. So, for example, in the family provision, in that jurisdiction, there are two competing things. One is straight dollars, but the other is the emotional, familial ties, issues. So all of those concepts that actually don't turn up in dollar terms. They can't be reduced to dollar terms. And so an issue that is of significance to even personal significance to a party can have some degree of proportionality, even though it doesn't have a monetary value as such. So it's not purely dollars and cents that determines what is and isn't proportional.
And the other thing that was going through my head is if you're a practitioner on the receiving end of such an application, without breaching your confidentiality to your client, all those sorts of issues, how do you, without just falling on your sword and saying, I can't say anything because I might jeopardise even during the course of a proceedings, you might, be facing one of these things because you have, timetable from the court order or something, and without, even if your solicitor your services were terminated, without jeopardising their case. So are you just faced with a situation where you have to say nothing and just cop the order?
No. There is case law that did not make it into this because I had a very limited amount of time. There's case law that says that client legal privilege is a very live thing and that courts must take into account a practitioner's incapacity to explain their conduct where client legal privilege may in fact be the reason for that. So in effect, there's a Davidson, and I think it's Suncorp, it's a Queensland Federal Court decision. His Honour noted that he had to give the practitioner the benefit of the doubt because client legal privilege had not been waived and could not be waived in those circumstances. So the practitioner could not actually give a fulsome explanation of what advice had been given and what steps had been taken and why these proceedings were commenced and the course that they took thereafter. So it is the case. Client legal privilege is very important because your desire to defend yourself is visceral and it's primal. But your first duty is still to your client. And inevitably, particularly if you get one of these situations where you've gone to trial, your client's lost, they're facing an indemnity costs application and you're facing an alternative order that you indemnify them or a Section 99 order, you're in a hopeless position of conflict immediately. You can't even talk to your client. So you have to cease acting if you haven't already. You can't have a conversation with them about whether or not privilege is going to be waived. You are stuck. But the court recognises that.
And just one final other observation was, I'm just going to get my train of thought here, was, I'll waive that question.
I have a quick question. From your description, it seems that Her Honour Justice Ward in NHB Inquiry number 5 and the Court of Appeal in Rahman are not entirely consistent. Should we be looking out for an appeal in NHB Inquiry, particularly given the animosity?
Look, maybe. I think the best thing I can say is that this area has received more attention of late than, in the early years of the Civil Procedure Act, and I think it is still developing. I think that's why Justice Bell, or President Bell as he then was, gave such a fulsome and wide-ranging decision in Moroniti and Mercia, laying down some really basic principles for solicitors. It's worth reading. It's not NHB Inquiry, so it's not sure. But yes, it is a developing area, and I think we can expect more developments.
And I imagine that they're not an application that should be brought lightly. You wouldn't want to.
No, you can get crucified for bringing it inappropriately. And proportionality applies to both the applicant as well as the respondent.
Hey, can I speak to Brenda? Sorry, just. The problem with me asking this question is that it reveals that I don't know the answer. I probably should. But I was intrigued, and I'm sure I've looked at this. When you talk, going back to the that conundrum of the whether there's a genuine offer of whether there's a genuine compromise, and as you know, the UCPR specifically provide for the walk away, the defendant to walk away, and so you get a bit of defendant succeeds on that, then the other plaintiff says, well, it was just an invitation for us to fall on our sword, and the defendant says, well, it's provided for in the rules, Yeah. But that we're still in that territory, aren't you? Just because it's provided for in the UCPR, you still have to demonstrate that there was a genuine compromise, and as you say, put on the evidence about costs incurred, etc., to say, or what we're throwing away. And I think was it
Jackson
or Jackson said, make reference in the covering letter that of all the potential cost orders that you would also you're abandoning for the purpose of achieving a compromise, etc.
And generally how bad that case is. So it's why when you make an offer under the rules, you often fulfil the Calderbank principles as well by explaining all that, it's unreasonable not to accept this offer because it helps you on that aspect. Look, it really is a matter of fact. Walkaway offers can be genuine offers of compromise, and particularly later in proceedings where it's going to be obvious to anyone that a considerable amount of costs have been expended, then it usually will be accepted that a walkaway offer will be a compromise on the part of a defendant. The issue in the particular case was that it was made at a very early stage, so that if the walkaway offer had been accepted, the defendant wouldn't necessarily be foregoing very much.
I think, Katherine, I was interested that I don't recall the name of the judgment. You referred to a decision of, I think it was Steve Campbell or Justice Campbell, where he
Canon Finance and Canon.
And he's like, no big difference between reasonable prospects of success or the Section 99 criteria.
Well, yes.
And I guess I haven't read the judgment, but I guess that is limited to the threshold issue rather than the whole question, because if I'm not mistaken, Section 99, it's also, another hurdle is that it's discretionary, isn't it? So I don't think that's the case with under the Uniform Act.
No, it's not under the Uniform Act, but the comment that His Honour was making was in relation to the distinction between no reasonable prospects of success and proceedings without, or incurring costs without reasonable cause. So I think you probably should read down that comment to just commenting on the scope of the second element of Section 99.
I understand that. I mean, Section 99 actually can have a broad application because it's any costs. I mean, it's what the English pompously refer to as the wasted costs jurisdiction, it could be a small portion of costs for you.
Yes, it's not designed purely for the cost of the whole proceedings following a trial. It is any element. That's why proportionality comes in.
Cool.
Just going back to the concept of serious, so is it right that, just my take on NHB number 5 was that it came down not necessarily to the implications of the disclosure of the information to the defendant, but the solicitor's knowledge around that?
Yes.
Is that right?
And I think that's actually a fair characterisation. There's got to be, I suppose I should start a bit further back. It's kind of like the difference between a mistake and negligence. Okay, so it's a quantum issue in terms of it's the quality, and it's a whole quantum level beyond mere mistake, mere misconduct. It's got to be serious.
I also just had another question, and this may be getting more into waiver than costs, but I mean, in a lot of these cases, as soon as somebody raises the Section 99 kind of issue against a solicitor, isn't there kind of a question about whether there's a waiver of advice given or something because it's the issue that's being brought before the court, or would that be something that the client has the choice to disclose or not disclose?
It is always the client's. The privilege is the client's.
Okay. So that would depend whether or not a solicitor could put on evidence or not, would then depend on what approach the client chooses to take.
Okay.
And just to be clear, there's cases, Section 99 is often brought by the opposing party, of course. It could be brought by the client. But
or the judge.
Indeed. But there's a line of authority generally where there's a dispute between a solicitor and their own client that says essentially if a client does bring some kind of proceedings or application against their own lawyer, that often operates as a waiver. So the solicitor in that situation can more easily defend themselves. So it's not so much a problem if the application or a claim's been made by the solicitor's own client, but where it's been made against by the opposing party, then what Katherine said earlier will apply.
Yes.
Okay, so in that case then, if an opposing party or the judge brought the application, then I'm just struggling to practically understand how it works in terms of does the client obtain separate legal advisors?
First thing you do.
Yeah, of course.
If you are subject, if those words come out of the judge's mouth, I intend to, I require you to respond to a Section 99 inquiry. You have to be given time to prepare, but the first thing you have to do is shift your client somewhere else because you're in a position of hopeless conflict.
Mm-hmm.
But interestingly enough, in one of the other Muraniti cases, I don't remember which one, it's the one that came down in the middle of this year. The Muraniti and Newell had continued to act for the clients all the way through, and they were criticised by the district court judge when Her Honour made her orders. But the Court of Appeal was less critical of that. And so there's, and that's because there's also the principle that just because, let's say Jackson and I are opposing parties and I want to cause him hassle by making him sack his lawyers, I could make an application under Section 99 and put him and his lawyers in a position of conflict. The courts recognise that I shouldn't have that control in that situation.
Yeah.
So if it comes out of the judge's mouth, absolutely. If it's an application made by the opposing party, you should think about it and think about whether it is appropriate. What the client wants to do, client properly advised on questions of conflict.
Independently advised.
Exactly.
So that's Kalila Napina.
Yes.
And yes, you can, if you can meet your obligations by sending the client off to get independent legal advice without losing them entirely, depending on what they say in response to that advice. So, but that's how it all works.
And Katherine, am I right to say that you also notify law cover?
Hell yes.
Yeah.
Of course, I think that's
that's
as well.
Certainly.
We
can. Yes.
Well, that was, thank you very much, Katherine, Brenda and Jackson. Very informative and taking time out of your busy day to present to us on a very interesting area, which is a very practical area in respect of costs, because at the end of the day, it's one of the big issues in litigation. So a really important issue, and maybe also the sign of the times. I think, the aggression in litigation seems to be, I just looking at the correspondence I see, it seems to be far more aggressive than perhaps it used to be. And I think almost a lot of correspondence has this threat to personal cost orders against practitioners, which I wonder sometimes whether there's conduct issues, but that's not for me to judge in those cases. But look, thank you very much for a very informative talk.